That I am an expert in many things. I'm not doing down my own expertise, but art and part liability possibly isn't one of those things I would have kind of had at the top of my CV. I wrote a short article about it a while ago, mainly because I was asked when I started at Glasgow University to teach art and part liability with Lindsay. And I realised upon reading the cases I did not understand it in the slightest. And that annoyed me because I don't like not being able to understand things. So I then went into commission to try and get my head around it, which I sort of think I've done. But I'm by no means an art and part liability expert. Having said that, I'm not quite sure who is, because it is complicated. So, okay, so what I'm going to do just to start with is a very, very brief refresher session on what we are talking about when we talk about art and part liability. It's a peculiarly Scottish concept. So art and part liability, we have a principle in Scotland that all who participate in a criminal enterprise are equally liable. We don't have, or at least not in the context of homicide, there are some aiding and abetting provisions in the law, but in the context of homicide we don't have a concept of aiding and abetting. You're either liable for murder, homicide, or what, or you're not. I'm going to use for the rest of the talk sort of the terminology of A1 and A2 to mean like the first accused and the second accused. So A1 is going to be the person who has direct liability. So they're the person who has the actus reus and the mens rea for murder. So A2 I'm going to use as the person who doesn't necessarily have those things, and that in order to convict them you have to resort to the doctrine of art and part liability. So the basic test is always the same, whether you're in any context, murder or otherwise. The basic test for art and part liability is that for A2, the secondary party, to be liable for the offence, they must have participated in it in some way first. That doesn't have to be very much. It could be as little as just providing some sort of assistance, supplying a weapon, encouraging the principal offender. It could be in the sort of kind of spontaneous fights we've been talking about, simply becoming involved in some way in that fight, but not being the person who ultimately causes death. But it does have to be something. You can't become art and part liable simply by being a bystander and watching and doing nothing, unless you're going to start to go down the lines of omissions liability where you had a duty to act, which we're not going to do just now. So you need to participate. But probably the more difficult part of the test is that you need to have a shared common purpose with the first accused. I will come back to what that means just in a moment. If that test isn't satisfied, you are liable only for your own contribution, whatever that may be. Art and part liability is particularly useful and this seems to come up in quite a lot of cases, where you simply, the evidence doesn't allow you to know whether it was A1 or A2 who actually caused death. There's a lot of cases in the reports like that. I mean, a recent example is a case called Fee against Her Majesty's Advocate, which was a case of a couple who had a young son, and for the first 2 years of his life he was horribly mistreated and subject to a lot of injuries. He eventually died from one of those injuries, and it must have been one of the two parties who inflicted that injury, but it was impossible from the evidence to tell which one of them it was. And through the doctrine of art and part liability, that doesn't necessarily matter. We can find both of them guilty of murder. What it does mean, and this is I suppose the controversial bit, is that you can find A2, the second accused, guilty of murder without them having either the actus reus or the mens rea of murder. And I suppose that is what, I suppose in some ways the whole nub of my talk comes down to that. That's maybe the question that needs to be considered, whether that's appropriate or not. Okay, so so far so good. In homicide cases, a distinction has kind of come up in the case law between what's called antecedent and spontaneous concert. Now, before we get into that, I think it's important to stress that whatever happens, whatever distinctions are made, the basic test always applies. You're always looking for participation and a common purpose. But then, once you get beyond that, any further directions that are given to the jury are very much going to depend on the facts and circumstances of the case. But this distinction has kind of come up in the case law, as I say, between antecedent and spontaneous concert. Antecedent concert cases are those where there was some form of pre-planning. I suppose the sort of classic cases like two people agree, as in Hopkinson, a case Claire mentioned earlier, that they're going to go out and commit some sort of robbery. But in the course of that robbery, one of them produces a knife and the victim dies. Maybe from what Sarah said, they're less common than the other sort, which is spontaneous concert cases, where there isn't, or at least you can't prove, any element of prior agreement. So a fight spontaneously arises, and in the course of that, involving multiple parties, and in the course of that, somebody dies. That said, I think this is where it becomes really complicated, is it's not always easy to tell from the evidence whether a case falls into one or other of the categories. You're not always going to know or be able to prove that there was some sort of prior agreement to commit a crime. And you do see in the case reports that sometimes cases are prosecuted on alternate bases, which makes it incredibly complicated because the test for the two, as we'll see later on, I don't think is the same. And some cases simply don't fit that categorisation. Like Fee, for example, the cases that went on over quite a long period of time. But that maybe doesn't matter because you can always fall back on just the general participation plus common purpose test. Okay, so we're going to briefly step back in history. And this, I think, is where there's a lot of confusion, I think, in the law, a lot of uncertainty in this area of law. And it can be traced back to, well, starting point, I suppose, is a case called Daugherty. So in Daugherty, this is a homicide case where a group of people were involved in a fight that, well, there was a plan in this case. It was an antecedent concert case. But the main thing is they in the case, the court held that if you're going to find a member of the group liable for murder on the basis of either part, you can do that if that particular person, the test is whether they had reason to expect that a lethal weapon was going to be used, even if they didn't actually, carry out the stabbing themselves. That is clearly an objective test. It's not relying on what they actually knew or thought. It's a test where you're looking at, well, would it have been obvious, or was there reason to think that lethal violence was going to result, or a lethal weapon was going to be used? Then came the case of Brown, where the court said, no, that's not right, that's a misdirection. Actually, what the test is whether A2 had in contemplation, as part of the joint purpose, an act of the necessary degree of wicked recklessness, such as a deceased to be stabbed by plunging a knife into his heart. That's a subjective test. That's saying that what you actually have to look at is whether, the secondary party had in their own contemplation, you're looking at their actual state of mind, what they actually knew or what they actually expected to happen. But then, so Brown stood for a while, then along came McKinnon, which is probably the leading authority now. And in McKinnon, the court didn't overrule Brown as such, but what they said is that the Brown approach is unwarranted in cases of antecedent concert. So the court made it very clear that what they were dealing with is the cases where there was a plan, the antecedent cases. And they said, and this is the test that tends to get quoted a lot in textbooks, that an accused is guilty of murder, arc and part, where, the blue bit, he actively associates himself with a common criminal purpose which, either includes the taking of human life or carries the obvious risk that life will be taken. So we've moved back again to an objective test. You're not now, contrary to Brown, thinking about what they actually had in their contemplation. You're thinking about, well, actually, was there an obvious risk, a risk that would have been obvious or should have been obvious to anybody that life would be taken. And that's confirmed in a subsequent case, Poole, again, that in antecedent concert cases, the test that you're asking is, well, was it objectively foreseeable that such violence as was liable to be used carried an obvious risk of life being taken? And if it did, and the accused participated anyway, then it's legitimate to find them guilty of murder. Stressing again, they do not need to have either the actus reus or the mens rea for murder. But it gets more complicated than that. Because Claire mentioned this case. Then along came a case called Hopkinson. As Claire said, Hopkinson was a case where the accused at least claimed that a plan had been made to go out and, I think, rob somebody, and a knife was being carried, but according to the accused's account, the knife was only ever going to be used to scare the victim. But actually what happened is the first accused used her knife to kill the victim. And what Hopkinson said is here. So Hopkinson tried to distinguish between, or the court in Hopkinson tried to distinguish between three different situations. They said that if the agreement, or the initial agreement between the accused was limited to scaring the victim without there being any foreseeable risk of injury, then you shouldn't be convicting the secondary party of murder or culpable homicide. But in these other two situations, where there was a foreseeable risk that the knife might be used either to inflict some form of non-fatal injury, situation 2, or there was a foreseeable risk that there might be a life-threatening injury, situation 3, it's legitimate to return either a murder or a culpable homicide verdict. Not at all confusing. Well, there's a couple of things about that, I suppose. One is that, although the court didn't acknowledge this, actually it's quite hard to reconcile that with what was said in McKinnon. Two things about that. So scenario 1, the yellow scenario, was a scenario that was used in McKinnon as an example of a case where it would be legitimate to convict of culpable homicide. But here you have Hopkinson saying, actually, no, you shouldn't be convicting of culpable homicide or murder in that situation. So you've got a conflict between the two cases. Situation 3, that's highlighted in grey, the situation where there was a foreseeable risk of life-threatening injury. In Hopkinson, they say, well, that could be murder or culpable homicide. In McKinnon, they're absolutely clear that the appropriate verdict in that case, as you have seen from the quote before, should be murder. Culpable homicide shouldn't be arising in that sort of case. So you've got two conflicting cases there. And I suppose the second point about it is that there is simply no further guidance given to juries about how you choose in situation 2 or situation 3, where you've got that choice between murder and culpable homicide. Now, you may see that's a good thing or a bad thing, depending on your views of flexibility in the law. That reflects some of the discussions that we were having earlier. Okay, so then, so that was all about antecedent concert, which, as probably going on what Sarah says, is maybe the least common of the two alternatives. But then you've still got these cases of spontaneous concert where events kind of rapidly escalate and there's no complete planning involved, but a fight escalates and ends in lethal violence. Having kind of gone through a lot of these cases, one thing that does strike me about the cases, and this is not to do with the law, which I'll come on to in a moment, is we did kind of speak at the moment about these kind of homicide cases being mundane and sort of, you know, not particularly kind of, almost implying they're not particularly serious. One thing that struck me when I read through a lot of art and part cases, particularly the spontaneous ones, is actually there is a horrible degree of brutality in some of these cases. These fights that get out of hand, it makes it sound like it's almost like a kind of a prank or a joke. Actually, lots of these cases involve pretty horrific injuries to the victim. You know, you're not talking about just kind of a single, almost accidental stab wound. You're talking about fights that involve real nasty brutality. Maybe I'm just a bit soft and not kind of hardened to these things, but really nasty brutality, where people are getting, you know, awful injuries, like multiple stab wounds, terrible bruising from just multiple parties laying into them, kicking them many times. It's not, I'm not sure mundane is quite, they're not premeditated, but they're still horrible and brutal. I think that's kind of relevant for when we think about whether, you know, what we reserve the label murder for. But anyway, that's a slight side issue. The legal issue is whether the Brown test, remember that one, the kind of subjective one, still applies in spontaneous concert cases, but McKinnon made it absolutely clear the court was only talking about antecedent concert cases. And I think the answer to that is we're not really sure. This is where I do get a bit hesitant at trying to kind of identify what the law is, because it's actually very difficult to identify what the law is, other than just the basic test of you need participation and common purpose. There are some cases, I've not listed them here, that suggest that actually if A2 is aware, if participates in a fight, and he or she, will be he probably, is aware that a knife is being used, but they carry on participating anyway, that's enough actually to make them guilty of murder. So there's some cases that say that. But then you get some variation as well. The three cases I mentioned here are all clear, or were prosecuted on the basis of spontaneous concert. You've got Crawford that says actually just being aware of the knife and carrying on is not enough. Actually, if you didn't appreciate that knife was going to be used to inflict kind of a murderous or a fatal injury, then actually you lack the intent necessary for murder, but could be convicted of culpable homicide. That's a bit of an odd thing to say, because the whole point of art and part is you don't need the intent for murder, but anyway. And then there's another case I came across, Patterson, where the court seems to be implying that actually you might need individual mens rea in spontaneous concert cases, and you should be thinking about whether A2 was wickedly reckless or not. But then you've got another case that actually came quite soon after that with a different bench, Raymond, where they say no, there's absolutely no question of individual mens rea arising, and that's a direction that's too favourable to the second accused. So it's quite difficult to actually pinpoint what the law is in spontaneous concert cases. Where do we go next? I suppose one thing is it's hard to know quite what is in the remit of the Law Commission's inquiry here. I mean, it's an inquiry into homicide, it's not an inquiry into art and part. But there is a basic question of whether art and part liability is the appropriate model at all, and whether we should adopt some sort of model that more formally distinguishes between the liability of two parties. So kind of in England and Wales there's a doctrine of aiding and abetting, which I don't know an awful lot about, but that's a way of distinguishing someone's contribution rather than just making them liable for the full crime. If you had to pick out one thing that was particularly troubling, I suppose it would be the test antecedent concert cases, where you can, well, if you follow McKinnon anyway, you can be legitimately found guilty of murder if there was if you join in an activity where there was a foreseeable risk of life being taken, and that's all it takes. Now, on one hand, you could say, well, if you're going to participate in some sort of enterprise that involves the use of knives, I mean, that's not a very good thing to do. And actually, maybe you deserve the consequences of that if fatal violence is a result. And I suppose as well, another justification for it is, well, by taking part in a group exercise, groups are inherently more dangerous than individuals, and actually you bring a group of people together, that increases the risk that something might happen, so you should reflect that in the law. But on the other hand, can you really say that somebody in that situation should be found guilty of murder? Is that appropriate? Or is perhaps culpable homicide a more appropriate verdict? And I slightly hesitate to mention the law in England and Wales because I'm certainly not an expert on that, but a similar sort of doctrine in England and Wales, not identical, but a similar sort of doctrine in England and Wales has recently been abolished by the courts, and with a much higher test before you can find somebody guilty on the basis of joint enterprise. Well, I'm not going to go into the law of England and Wales, but a similar idea is no longer possible in England and Wales. There is, as I said, inconsistency and vagueness in the law. That may be a good thing, that may be a bad thing. But it's certainly a complicated issue for juries. I don't need to keep going on about this, but if ever there was a case for written directions or routes to verdict, I think art and part liability is that case, because judicial directions in homicide cases are complicated enough already. If you're then adding in multiple accused, 2 different tests, one for antecedent concert and one for spontaneous concert, because you can't always tell which it is, I think you've not got the hope in hell of a jury being able to follow that and remember it. And there was one case, I think it was Patterson, where I read that the directions to the jury had lasted over the course of 2 days. And I'm not sure I'm sure they didn't mean 2 full days, but certainly they'd started on one day, there'd been a break overnight, and the judge had come back the following day. And that's not the fault of the judge, it's a very complicated area. And I suppose I would only end by saying, the solution is kind of parasitic on what is the choice of routes that you take in relation to homicide more generally. I think that probably has to come first. And if you are going to then consider art and part liability, then that kind of comes after that.